Dear students, viewers, and the subscribers, welcome to the IAS Mentor. This will be our lecture number 102 in the series Indian Polity. The Indian Polity Series is just to begin with. So this will give you a basic fundamental idea about the subject Indian Polity. But as we'll proceed, we'll do more series, more initiatives will come. And the next that we are planning to do is do a series on the current affairs for the subject Indian Polity, which will be especially helpful for the students appearing for the prelims 2025. So within a week or something, I'll start doing a series on the current affairs as well. So that's a small update to the students who have been asking me to do a series on the current affairs. Especially will be extremely useful to the students appearing for the prelims 2025. All right. So with that, let me get into the topic that I want to discuss today. So in the last class, we have discussed about the center-state relationship. So after the center-state relationship, naturally we should study about the union territories as well. Now center-state relationship is only between the center and the states. That means between the central government and the state government. But whereas the union territories, they are not considered to be states. The union territories are not in a federal relationship. If you say union territories, they are all considered to be part of the union itself. That is why they are called as union territories. And who is the administrative head of the union territories? It is of course a president. It is a president who has to carry out the administration in all the union territories. But under the constitution, the president can appoint an administrator also. And that administrator can be designated as an administrator. He may be designated as a chief commissioner. He may be designated as a lieutenant governor. So the purpose of ease of administration, the president can appoint an administrator and designate them by any of these names, as I said. So that is how the union territories are administered. So therefore, the union territories are not in a federal relationship. So that is something that you'll have to categorically understand. Today, if you see under the Constitution of India, we have 28 states and presently we have 8 union territories as well. Now, before I get into the constitutional provisions related to union territories, now why do you think that some of the territories in India has been given the status of union territories? So there are multiple reasons. So we'll try to understand that, and then we'll try to understand certain other constitutional provisions with regard to the union territories. And of course, finally, before we conclude, we'll also understand the special status that is conferred upon the union territory of National Capital Territory of Delhi, because the National Capital Territory of Delhi, though is a union territory, it is having special status. Not only National Capital Territory of Delhi, today we have Puducherry also some special status, because Puducherry also, despite being a union territory, it is having a legislative body. And similarly is the newly created union territory of Jammu and Kashmir as well. So we'll touch upon these areas also, but majorly we'll focus upon the constitutional provisions related to the union territories. All right. So the first and foremost understanding that we should have is that why certain territories in our country has been given the status of union territory. So there can be number of reasons for that. So largely, if we combine all these reasons, broadly there are 3 reasons as to why the union territories was conferred, or the status of union territory was conferred upon certain territories. In fact, before I get into the union territory, what is very important is what was the position at the commencement of the constitution. If you see at the commencement of the constitution, that is on 26 January 1950, in fact, there was no union territory under the constitution. The union territories came into existence only in 1956, after there was a large scale reorganization in our country. So on 26 January 1950, when India had its own constitution, there were only 4-fold states: Part A states, Part B states, Part C states, and Part D states. In fact, it is this Part C and the Part D states, which were at the commencement of the constitution, has been largely classified as union territories in 1956. So it was the 7th Constitutional Amendment Act in 1956, which has made some changes in the constitution. And thereby it led to creation of 14 states and 6 union territories. Now all these things are done largely on the basis of Article 3 of the Constitution. I have already in detail explained about Article 3 of the Constitution, based on which the internal reorganization can be done. So based on this, these internal reorganization has been done. Now, what is more important for you to understand is, now what was the basis on which these 6 union territories was created, which is presently 8 union territories. The basis on which this reorganization has happened is based on majorly these 3 parameters. What are the 3 parameters? Based on political and administrative convenience or importance, and then the cultural and the strategic reasons. So for example, and of course the population as well. In some of the areas there were less population, so population was also one of the factor. So it is majorly population. If you see the union territories, largely they have got less population. But apart from that, most importantly, the cultural and strategic reasons as well. Say for example, Lakshadweep, Andaman and Nicobar Islands, not just because of population, they were strategically very important. Look into their locations. Their locations are in the seas. So therefore, strategically it is very important for our national security. And because they are strategically important, they should be under the control of the union. So therefore, they were given the status of union territories. Look into Puducherry. Puducherry has got a very distinct culture, because if you look into the history as to how Puducherry became part of India, now Puducherry was ruled by the French, and subsequently after India became independent, then Puducherry was acquired. So because the people are having a distinct culture there, so Puducherry was given the status of an union territory. So therefore it could be because of population, it could be because of strategic reasons, it could be because of cultural reasons. It can also be because of political and administrative reasons. When I say political and administrative reasons, it is also because of the fact that politically it is very important that certain areas should be under the control of the union government, and administratively it should be under the control of the union government. So for example, Delhi is one such example. So Delhi is a place where the national capital is there. So despite the fact that national capital territory of Delhi is having a huge population, it is both administratively and strategically very important. It is in the control of the union government, because that is where the entire national institutions are there. Institutions of national importance are there. The union government, the secretariat and all those things are placed in Delhi. So therefore, you cannot give it to the complete control of the states. So considering all these things, certain territories in our country has been given the status of what is called as an union territory. So that's a first understanding you should have. So accordingly, how many union territories do we have right now? We have got 8 union territories, and we have got what is called as 28 states. So among all these union territories, today there are only 3 union territories which has got a special status. When I say special status, there are 3 union territories today in our country which has got a legislative body of their own. While the constitution itself authorizes the states to have their own legislative bodies, but in case of the union territories, if at all a parliament is making a law, by that law they can have their legislative bodies. All right. So this is some basic information. So if you look into the constitution, which part in the constitution deals with all those things? It is part 7 of the constitution, right from article 239 to article 241 of the constitution, which talks about all these things. All right. So let us proceed further. Let us try to understand some of the important constitutional provisions in general related to the union territories. Once I am done with that, then I will move on to the special case of Delhi, because Delhi is one such union territory which is having a special status. All right. So the first and foremost important constitutional provisions with regard to the union territory is article 239 of the constitution. So what is article 239 of the constitution? I am repeating it again. Article 239 of the constitution. So what is article 239 of the constitution is saying? All the union territories, that is the union territories, shall be administered by the president with the help of an administrator. So therefore, whether an union territory is having a legislative body or not a legislative body, the union territory is ultimately under the control of whom? It is under the control of the president. When I say president, the president is just a nominal executive. So therefore, the president has to act in accordance with the aid and advice of the Council of Ministers. That is the Union Council of Ministers, which means the union territories are directly under the control of the union government. That's a basic understanding you should have. So that is why the union territories are not in a federal relationship. The states are not under the control of the union. The states are independent authorities. Although there is certain element of division of powers, certain element of control that the union might have, because India is not a truly federal political system. But apart from those areas, the states are independent. But whereas the union territories are under the control of the President of India. But the President, instead of directly administering this area for the purpose of convenience, he can appoint an administrator. And how that administrator can be designated as per the Constitution of India. He can be designated as a lieutenant governor, he can be designated as a chief commissioner, or he can be designated as a uh, as well as an administrator. Say for example, in case of Chandigarh, which is a union territory, he is designated as an administrator. In case of Delhi, in case of Puducherry, they are designated as what is called as a lieutenant governor. So it is for the president as to what kind of designation he gives to that particular administrator. All right. So these are all some basic understanding you should have about the union territories. Now, apart from that, while Article 239 says that the union territories shall be administered by the president. Apart from that, if any union territory is to be given a special status, that means if any union territory is allowed to be allowed to create their legislative body of their own, can it be done? Yes, it can be done by a law that is made by the parliament. So specifically, that power is given to the parliament by virtue of Article 239A. So what is Article 239A is saying? Article 239A is saying, if at all the parliament thinks and if it wants, they can make a law, and by that law they can create a legislative body to any union territory. Not only a legislative body to any union territory, they can also allow that particular union territory to have what is called as a council of ministers. So for example, today we have the government, the Union Territory Act, the Government of Union Territory Act 1962, under which Puducherry is allowed to have a legislative body and also a council of ministers. So how this law is enacted by the parliament? By virtue of what is called as Article 239A of the Constitution. Apart from that, ultimately what did I say? Who is the administrator, or who is having the control over the union territories? Who shall administer the union territories? The president. So under Article 240 of the Constitution, the president can also make regulations for the good governance of the union territories. That is also possible. But however, there are few exceptions to this. So ultimately, the president is the head of the union territories. Therefore, he can make regulations. Why the word regulation is used instead of the word laws? Because the president is an executive. When an executive is making something to govern a particular area, that is basically what is called as a regulation. But if it is done by legislative body, largely it is considered to be what is called as a law. So therefore, the president, who is an executive, he can make regulations for the better administration and better governance of certain union territories. What are those union territories? He can do so with regard to Andaman and Nicobar Islands. He can do so with regard to Lakshadweep. He can do so with regard to Dadra and Nagar Haveli and Daman and Diu, and also in case of Puducherry. But however, the most important thing is, what is difference between the other union territories in relation to Puducherry here? Well, Puducherry is the only union territory among all the 5 union territories under Article 240. Puducherry is the only union territory which has got a legislative body. So therefore, there is an exception that is given. While the president can make regulations for the better administration of these union territories, including Puducherry, but in case of Puducherry, the president can do so only when the legislative assembly is suspended or dissolved. If the legislative assembly of Puducherry is functional, if it is active, then the president cannot make any regulations. But he can do so in all the other union territories, which is mentioned in Article 240. But in case of Puducherry, when he can do that? Only when the legislative body is not functional. Okay, so that is what you will have to understand. Apart from that, there is also provision for the administrator to promulgate an ordinance. Can you give me an answer to this particular question? That is, which article in the Constitution gives the power to the president and the governor to promulgate ordinance? The president can promulgate ordinance for the entire country. The governor can promulgate ordinance for that particular state. We have already seen that. So the president can do for the entire country, president for the state. So which article? Which is the respective article for the president and the governor? Please put your answers in the comment box. So similarly, the administrator of a particular union territory, he or she can also promulgate an ordinance for that entire union territory, wherever he is an administrator. But however, when it can be done by an administrator anytime which is not having a legislative body. But if any union territory is having a legislative body, it can be done under only certain circumstances, when the legislative body is not in session. And once an ordinance is promulgated in a union territory which is having a legislative body, that ordinance has to be placed for the approval of the concerned legislative body. And within how much time the legislative body has to give its approval? The moment the legislative body comes into session, it has to be approved within a period of 6 weeks. That is what is very important. If the legislative body does not approve it within a period of 6 weeks, then the ordinance would continue, then the ordinance would cease to exist. Say for example, in case of Puducherry, if the legislative assembly is not in session, then at that time the lieutenant governor of Puducherry can promulgate an ordinance. And once ordinance is promulgated, whenever the legislative assembly of Puducherry comes into session, the legislative assembly of Puducherry has to approve this ordinance within 6 weeks from the date of its reassembly. If they don't do it, then the ordinance would lapse. It cannot continue to exist. But even before 6 months, if the legislative assembly of Puducherry wants, in the example that you have taken, they can pass a resolution and they can revoke this ordinance. So these are all very much possible under the Constitution of India. And apart from that, the administrator, he can withdraw the ordinance at any point of time, independent of the legislature. So these are all some of the constitutional provisions you'll have to understand. So what is very important is, you remember Article 239. Who is the head of the union territory? It is a president. But the president can also appoint certain administrators. And apart from that, under Article 239A of the Constitution, the Parliament is empowered to make a law, and by that law they can create or provide for a legislative body to the union territories. They can provide for Council of Ministers to the union territories. Apart from that, under Article 242 of the Constitution, the President can make regulations for the good governance of certain union territories. But in case if the union territory is having a legislative body, only when the legislative body is suspended, the President can exercise this particular power. Very, very important provisions. And apart from that, the administrator can also promulgate ordinance in case if the legislative body is not there in that particular state. And if the legislative body is suspended also, in a case where there is a legislative body, the administrator can promulgate an ordinance which has to be approved by the legislature within a period of 6 weeks once they come into session. Apart from all those things, if any union territory wanted to have an independent high court of its own, today not every union territory in our country is having its own high courts. Only very few union territories has got high court of its own. Say for example, Delhi is one such example. And apart from Delhi, it is only Jammu and Kashmir. These are the only two union territories which has got a high court of its own. So therefore, if you have to establish a high court of its own for any union territory, whose authority to do that? It is the Parliament of India whose authority to establish high court of its own for a particular union territory. So that is also a power which is given to the Parliament by virtue of the Constitution under Article 241. Very, very important. Each and every single point that I am discussing is relevant for your prelims examination. Alright, is that clear to all of you? And apart from that, the remaining union territories, they are not having the union high courts of their own, but an adjoining high court or a nearby high court is having jurisdiction over these union territories. Say for example, the High Court of Madras is having jurisdiction over the union territory of Puducherry. The High Court of Kolkata is having jurisdiction over the union territory of Andaman and Nicobar Islands. The High Court of Kerala is having jurisdiction over the union territory of Lakshadweep. The High Court of Bombay is having jurisdiction over the union territory of Dadra, Nagar Haveli and Daman and Diu. And the Punjab High Court is having jurisdiction over the union territory of Punjab, and Haryana High Court is having jurisdiction over the union territory of Chandigarh. Delhi is having its own High Court, and then Jammu and Kashmir is also having its own High Court. So these are all the understanding you should have. So I'm sure that these things are quite clear to all of you. So now, one last thing before we complete the lecture is also the special status that is given to National Capital Territory of Delhi. So what is the article that is giving the special status to National Capital Territory of Delhi? So presently it is Article 239AA which is giving the special status. Let me just discuss as to what is the special status also. But before I discuss the special status, let us try to understand as to what is the genesis of National Capital Territory of Delhi. If you look into the commencement of the Constitution, National Capital Territory of Delhi was part of the Part C state. I said that it is only the Part C state and the Part D state which were converted as union territories. So at the commencement of the Constitution, Delhi was a Part C state, which is basically a commissioner-led province. But however, after Delhi became a Part C state at the commencement of the Constitution, subsequently there were demand that was brought in front of the Supreme Court that Delhi should be given a full-fledged state. Why? Because Delhi was having a huge population in terms of population. So therefore, there was some element of demand that Delhi should be given a status of a state. But at the same time, the central government or the center was not willing to give them the status of a state, considering what is called as the strategic importance of Delhi. So therefore, to study this entire matter, a commission was appointed. So what was a commission that was appointed? Sorry, a committee was appointed. A committee was appointed by under the leadership of S. Balakrishnan. So committee was appointed, and this committee suggested a midway to resolve this particular issue. So what is a midway that it has suggested? Okay, for the national security and for strategic reasons and administrative convenience, Delhi should not be given a full-fledged state. But at the same time, you cannot deprive too many people, because the population of Delhi is so high. So you cannot deprive too many people of their democratic rights to participate in election, to vote in election, to elect their government. So therefore, a midway can be arrived. And what is this midway? That Delhi shall be given a special status. What is the special status that it was recommended? While Delhi would continue to be an union territory, but Delhi may have a legislative body. Delhi may have an elected government. But however, it would still continue to be an union territory. With regard to Delhi, still Article 239 will be valid, because in any union territory, who is going to administer the union territory? It is a president. But within that, let us give the union territory of Delhi a special status. So in line with this particular recommendation, the constitution was amended. A new article was inserted to give a special status to National Capital Territory of Delhi, that is Delhi, by inserting this Article 239 AA. So what are the special provisions that was given to Delhi by virtue of this particular article? First of all, the name of Delhi was changed. From just Delhi, it was renamed as National Capital Territory of Delhi. That is the first thing that has happened by this amendment. And apart from that, the administrator of Delhi shall be designated as what is called as Lieutenant Governor. That was also mentioned. And apart from these things, that Delhi shall have what is called as a legislative assembly. So today, if you look into Delhi, how many MLAs can be elected? Can you put it in the comment box? Okay, I'll give the answer. There are 70 MLAs who can be elected, and this was possible because of what? Because of Article 239 AA. And apart from that, Delhi can also have what is called as the Council of Ministers. So this is again very important. So all these special status has been conferred upon Delhi. So I'm just repeating it again. The name of Delhi was changed, and then the administrator of Delhi would be designated as Lieutenant Governor. And apart from that, there can be legislative body, and then there can be a Council of Ministers. And because as a legislative body, the power was also given to the legislative body to make laws in case of Delhi. So the Legislative Assembly of Delhi can make laws on all the items in the state list. We have already seen that whatever item in the state list, in case of states, the state legislature can make laws. And because the Legislative Assembly of Delhi is having a legislative body, that is a Legislative Assembly. So the Legislative Assembly was also empowered to make laws on all the items in the state list, but not completely in all the items, subject to some exceptions. While they can make laws on all the items that is mentioned in the state list of the 7th schedule of the Constitution, but except item number 1, 2 and 18. So what are these items? 1, 2 and 18 correspond to. Item number 1 corresponds to what is called as public order. Item number 2 corresponds to police, and item number 18 corresponds to what is called as land. So except for public order, police and land, in other areas, the Legislative Assembly of Delhi will have the right to make laws. And then the Lieutenant Governor, in whichever area that the Legislative Assembly of Delhi is capable of making laws, on all those areas, the Lieutenant Governor of Delhi shall act in accordance with the aid and advice of the Council of Ministers. That is the Council of Ministers in case of National Capital Territory of Delhi. So this was a special status that was given to Delhi, which continue to exist even today. But despite all these constitutional provisions, there is a lot of tussle that was happening between the National Capital Territory of Delhi and Puducherry, National Capital Territory of Delhi and the Union Government, which I'll subsequently discuss in a separate lecture. All right. So with that, I'm coming to the end of this particular lecture. So I'm quite sure that it would given a broader idea as to what is the constitutional provision of Union Territories, how the Union Territories came into existence, what are the other important dimensions related to constitution, related to the Union Territories, and how the special status was given to the National Capital Territory of Delhi. All right. So with that, please come to the question, the practice question, because every lecture we want to do one practice question. who or which among the following has the power to establish the high court of its own in case of union territory? If at all a high court is to be established specifically for a union territory, who can do that? Is it the President of India? Is it the administrator of the union territory? It is the Parliament of India? Is it the Union Cabinet? So please put your answers in the comment box, and your comments are really going to motivate me. And if you have any suggestions, please do reach out to me, and you can consider me as your friend, or you can consider me as your mentor, guide, whatever it is. But I am someone who can help you in clearing your examination. So please do reach out to me. Please do not hesitate to reach out to me. And if you like this video, you can share it with your friends and family members. So thank you very much. All the very best.